Good evening, everybody. Buenas noches, buenas tardes a todos. Saludos. My name is Patricia Perez, and I am an AARP California volunteer, and I serve as a state president emeritus. Welcome, everybody. And on behalf of AARP California, it is my pleasure to welcome you to our monthly Let's Talk Dinero chat, when we're here to support your financial security. I know that planning your financial future and protecting your assets may be a bit overwhelming at times, and that there's so much information out there that it may be difficult for some of us to know what to do or where to go. But that's why we're here. Today, you're going to hear from the pros about what you need to do to ensure that your hard-earned, valuable assets are distributed according to your wishes after you're gone. Talking about our death or someone else's, death may be uncomfortable to some, but it is necessary, especially if we want to make it easy for those we are leaving behind. You will learn about estate planning, wills, trust, probate matters, conservatorships, and more. And I know that this is just the beginning of a discussion, so I know you have many questions, so please feel free to, ask your questions on the chat. We're going to leave time to answer your questions. November is Family Caregiver Month, and today we're going to focus on estate planning for family caregivers, as they often deal with important legal matters on their loved ones' behalf. And I mentioned we have two incredible pros, and I'll let them introduce themselves to you. We have two attorneys, but first I'm going to turn over the program to Daniela Hernandez to introduce herself.
Thank you so much, Patricia, and thank you so much for the invitation to be here today. So my name is Daniela Hernandez, and I'm an attorney here in California. My area of focus is in trust and estates, so specifically estate planning and trust administration. I have recently been focusing more on the trust administration side, which has shown me just how important it is that your estate plan is written correctly and with a lot of things in mind. So things that we'll definitely touch on today. Thank you again, Patricia.
Perfect. And Catalina, please, if you don't mind.
Yes, hi everyone. So my name is Catalina Reynoso. I am also an estate planning attorney. I say that I'm an elder law attorney because aside from estate planning, trust administration, I do conservatorships and Medi-Cal planning as well, along with special needs planning. And so today we're going to talk about that as well. My office is in Long Beach and I have a remote location in Santa Ana. I'm passionate about community educating because I was raised by my grandmothers and my physically disabled aunt.
Catalina, we have something in common, and I was raised by my grandfather, so I know a thing or two about caregiving, so thank you so much. Let's see. So I mentioned that we have two pros with us, and this is being recorded, so if you miss some of the information, don't fret, because later the video will become available. I know some of you are going to be taking notes, which is wonderful, but this is being recorded and you'll be able to view it later. So let's see, to start the discussion, Daniela, do you want me to turn over the program over to you? Go ahead.
That'd be great. Yeah, I'll go ahead and I will share my screen with everyone. Okay. So let me know if you can't see this. All right, are you able to see my PowerPoint slides? Okay, great. So we are going to get started with just, well, I don't know if we wanted to start with a poll question or if we wanted to dive right in.
No, we can start with a poll question if my pals at ARP are ready. Okay, so thank you for pausing that. Okay, so we're going to start with a simple yes or no, and this will help Daniela in her presentation. Is I currently have a will or trust in place? So please just yes or no. And this will give you both of you a good sense of where people are. So please just, a yes or no. Let me
Yeah, it just
see.
gives us a sense of, how, yeah, if folks already kind of have an idea, so this is good.
Yeah, so it's surprising the majority do not, that do not have
It's a
a
good thing
will or
they're logged on today because after
yes,
this, I think
you're
everyone's going to feel more proactive.
absolutely. All right. Okay. Now that you guys know where our audience is, and you can see why there's so much, the need for this. And remember, if you have questions, add them. But now, okay, Daniela, take it away.
Okay, great, thank you. So I'm going to that. So first off, just to start with, with the question, so do folks have a will or trust in place? For those who do not, maybe it comes from not knowing what a will or trust are. So this first slide denotes what a will and a trust are. I can go ahead and first explain how these two documents are similar. So both a will and a trust will allow you to nominate an individual who will manage and distribute your assets when you die. So in a will, that is going to be an executor. In a trust, that is going to be a trustee. Both of these documents or allow you to specify how your assets are going to be distributed after you die. So for example, if you want to leave gifts to specific family members, so I, leave my brother $10,000, or I leave my artwork and jewelry to my good friend Anna, right? So these are things that you can include in these documents, including, let's say you need to disinherit somebody, somebody who would normally take, who is an heir and would normally take from your assets. So this would be the place to say, this particular person should not receive anything from my estate. So that's how these two documents are similar. Different differences between the two. So a will, you can amend it, you can revoke it at any time. With a trust, you can also do that if it's a revocable trust. So there's a revocable and an irrevocable trust. So an irrevocable, you cannot make changes to it. So just keep that in mind. When most of the time when we talk about trust, we'll be talking about revocable living trusts. So there's that little difference there with those two. With a will, you must go through probate after you pass. So that is one of the big things that or one of the biggest reasons why we encourage people to have trusts done, because the trust will avoid the probate process if it is done correctly. And we will go into what the probate process looks like and what that is shortly. Another thing about wills is that the administration of your estate will be public because it's going through probate court. These matters are public. And so with a trust, if it's done correctly, it will avoid probate. You will not need to go to court. Your family members will not need to go to court. And so there's more privacy around, your estate, what you're leaving, and what that administration is going to look like. Another big difference between a will and a trust. So a will only go into effect after your death. A trust is different because a trust, all of these things that we're talking about, that you'll be able to nominate a successor trustee to manage and administer your assets once you're gone. In addition, that person will begin managing
paper too.
taking care of your assets should you become incapacitated. So that is a big difference as well between the two. And so these two documents are just two important documents that make up a comprehensive estate plan. So usually when we talk about an estate plan, there's lots of different documents involved. So these are just two of them. So hopefully with that, we have an idea what a will and a trust are.
If I
And
can
the
add one
differences.
thing, Daniela,
Yeah, please.
I don't know that it's in your presentation. I'm sorry if it is. This is a good point to include that in California, if you have a trust and you receive Medi-Cal, there will not be Medi-Cal recovery after you pass away. Is that in your presentation? If not, I
It
could
is
touch
not.
lightly.
No, no,
Okay,
please
that's a
go
good
right
area
ahead.
to
Yeah.
include it. So, if you've received Medi-Cal in California now, the state of California only recovers, which means there is a bill for the care that you received that Medi-Cal paid. And this is different than Medicare. I don't want everyone to get afraid and say, oh, well, I have Medicare. Is there going to be a bill? No, I'm talking about Medi-Cal, which you have to apply and qualify for based on your income. If you receive that and you are in skilled nursing Medi-Cal is the only one that has a bill now. And if you have a trust, whatever you put in the trust, there's no recovery from. That means the bill doesn't need to be paid as long as all of your assets are in your trust. It's completely legal. It's been the law ever since January 1st, 2017. And it's another reason that I really encourage my clients. Maybe they don't receive Medi-Cal now, but what if they're thinking about applying, or if they ever need skilled nursing in the future, why not benefit from Medi-Cal and then not worry that there's going to be a bill that will have to be paid after we pass away from our home or the equity in our home.
Thank you, Catalina, for sharing that. That's really important.
Um,
Wonderful. So going on to the next slide, as I promised, we were going to touch on probate. So as you can see on the screen here, probate is a court supervised process whereby your creditors are paid and your assets are distributed to your heirs and beneficiaries after your death. So again, this is all done through the court system. There's a judge who makes the decision. Nothing will be distributed until the judge orders it. So it is a time intensive process and it is costly. Now, an estate will be subject to probate if one of two things happen. So one will be if you pass away with a will and only a will. So when you have a will, that is called testate. If you die without a will, that's called intestate. So if you die without a will and the value of all of your assets is over $184,500, then it will have to go through, your estate will have to go through probate. So as you can see here, it mentions nothing about a trust. So again, a highlight about a trust. If you have one, you do not need to go through the probate process. So that is definitely a big benefit of a trust. So let's see, let's say what happens if you were to die without a will. So you don't have anything written that specifies how you want your assets to be passed on to your kids, to your family members. So what happens is that California has intestate succession law, and so that dictates how your assets are going to pass. So, and just to give you an idea, what that looks like is if you are married and you pass away, your assets will go to your spouse. If you don't have a spouse, it would go to your children. If you don't have children, it would then go to your parents. If your parents are not alive, then it would go to your siblings. If you have no siblings, then to your grandparents, and so on and so forth. So, you know, the importance of having these documents in place is being able to say for yourself how you want your assets, your property to be distributed. Otherwise, it would just go to the default to the intestate succession law. So that's, you know, something else to keep in mind. If that's important to you, if you want to be the one who makes that decision, then this is definitely a way to do that. So Catalina, if at any point, you know, you want to jump in, add anything to this,
Do you talk
feel
about
free.
how long probates take? Because I think we're talking about probate and why we want to avoid it. And one thing I always
Mhm.
highlight is you could be in probate court for a year and a half, 2.5 years if you know things aren't going right. If the court thinks you're not providing something, or any little hiccup really pushes your case out, unfortunately. And so the nice thing about a trust is that you're not in court, so it's nice and fast. You get all the copies of or the beneficiaries to everyone, see if they approve off on the distribution, pay off the decedent's debts, and hopefully you can start making distributions in months instead of over a year. So that's a really big highlight for why people will want a trust instead of a will. Um, just wanted to add that.
So
Aside,
even if, sorry, so I know that I'm already jumping in on with a question. So even if you do have a will, it might take a year just to go through probate?
easily.
Oh, okay.
Yeah.
Good to know.
Depending on the county. Some counties
Yeah.
are more bogged up than others.
Uh-huh.
Yeah.
All
Yeah.
right. Thank you. Go ahead, Daniela. I know we're jumping in on your presentation.
No, that's great. That's a good question. So to delve in a little bit more about trust and the benefits of trust. So how does a trust work? So the way that a trust works is it's just, a legal document. You are still going to remain in control of your assets for as long as you are alive and you have capacity. So once you no longer have capacity, then your successor trustee who you will nominate will then take over and be able to manage your finances, or will be able to manage your trust assets for you. And then of course, once you pass away, then the successor trustee will either begin to do that or continue to do that. But until then, you remain in control. You remain in control of your assets. It is just the trust that holds legal title to your assets. So, for example, if you have a house, bank accounts, brokerage accounts, you will need to name them in the name of your trust. And this is how your assets are then protected. And this is the only way for you to actually avoid probate. Because there are cases where people have a trust in place, they've made all the decisions, it's on paper, they've signed it, but then they don't do the most important step, which is actually transferring those assets or transferring the assets into the trust, which just means having the trust hold legal title. So, because all of these assets are now named under the name of your trust, once you are no longer able to handle that, your successor trustee will easily be able to deal with all of those things because it's all been named under your trust. So, if any of you do move forward and create a trust, that is going to be key. It's not just about getting the documents done and signing, it's also taking that extra step and making sure that you transfer title to your trust. As I previously mentioned, there are revocable and irrevocable trusts, but for revocable trusts, you can make changes to it as many times as you need to. We actually oftentimes, recommend that our clients who have created estate plans that they revisit them, every few years. If there's a big life event, if there's if the family gets bigger, they haven't, a new child is born, or just big life events, you want to review those documents to make sure that the wishes that you stated in there remain true. Maybe you need to change a trustee. Maybe you name someone who has now passed away, or you name someone who you actually no longer trust. So you'd want to, be able to make those changes. Also changes to the gifts that you leave. Maybe you no longer want to leave your brother all this money, or maybe now you want to give him more. So, a revocable trust, you can always make changes to it.
It's frustrating to finally log in.
I think that's important to keep in mind. You by no means need to stick to everything that you have in there. It's not, set in stone at that point. So, that shouldn't be a reason to say, oh, maybe I shouldn't do it now. Maybe I should wait. It's always better to just get it done. And if you need to make any changes in the future, you can do so. And then lastly, another point I wanted to make is that you can do very sophisticated planning with trusts. And I won't get into all of those right now because we only have a limited amount of time. But something that I think a lot of people find important that they're able to do is if you have children who, for example, are minors, so they're under the age of 18, you want to be able to specify how their inheritance is passed on. So if you plan to leave them, if you're in a good place and you want to leave your kids with a certain amount of money and you're concerned about their ability to manage that money, and they actually don't even need to be minors, right? Maybe they're adults and maybe the way that they handle their finances is a little questionable, and you want that money to be able to be there to help them when they need it, and not just have that money all at once and let them do whatever they want with it, right? So if that is the case with trust, you are able to say, I want to leave this amount of money to my children in trust. And so what that does is the money that you're leaving to your children will be placed in individual trusts for each of them. And then with that, that money is also protected from creditors. Let's say if any of your children are married and they have to go through a divorce, that money is protected. You can specify, if your kids are minors and something happens to you, and you want to be able to specify, I want my kids to receive their distributions at age 25. I want half of it to be distributed to them at age 25 and the other half at age 40, or whatever age you think is appropriate. So there are a lot of it's very specific and custom and particular to your situation, and these are all things that you can discuss with an estate planning attorney, and they can give you better advice as to how to structure your trust for the goals that you have.
Perfect.
So, really great thing about trusts.
Perfect. And Daniela, I've heard about living trusts. What is the difference? Is a trust the same as a living trust?
So that's typically the name that we use for them. Living trust, a revocable living trust, or an irrevocable trust. So yeah, that's just
It's the same
name.
Okay.
Yeah.
Perfect. But I love that it's able to not only be specifically customized to your own individual needs, and like you were saying, that sometimes you may be concerned, let's say if you have an adult child, or that you feel like maybe they may not be ready to assume responsibility for a lump sum, so maybe they'll get increments and the trustee would be responsible for that.
Exactly. Yes.
Perfect. So you want to continue your presentation?
Yeah, so the other thing that I wanted to touch on before passing it over to Catalina, or actually, sorry, I have 2 more slides. So as I mentioned, an estate plan consists of different documents. So if you are to go to an estate planning attorney and create a trust or an estate plan, there will be different documents involved. So one would be a trust. Another would be what's called a pour-over will. So it's a will, but this particular will is more of a backup plan. And so whatever assets were not transferred into your trust, the will sort of captures those. And the will states that it's your intention, because you created this trust, it was your intention that these assets be a part of your trust, and that kind of helps avoid probate in that sense if you didn't retitle some of your assets. So that's the trust. A pour-over will. You will have an advanced healthcare directive. So if you become incapacitated with this document, you appoint an agent to make medical decisions on your behalf. So these include end-of-life decisions such as organ donation, whether you wish to be buried or cremated, and what kinds of medical treatment you would want or would not want to receive if you cannot speak for yourself and if you cannot make that decision for yourself. So again, it's a document where you explain those things, where you state what things you would want and would not want. So this really helps ease unnecessary stress for your loved ones when, you know, something, you know, happens, unfortunately, and you cannot make those decisions for yourself, and you don't leave your family members thinking, you know, what would she have wanted? What would mom have wanted? What have dad have wanted? You already have those in a document that, you know, the doctor would just then follow. So that's an advanced healthcare directive. There's also a HIPAA authorization. And so that document just authorizes your physicians to disclose your medical information to your agents that you nominate in your advanced healthcare directive. Next on here are deeds. So again, going back to the making sure we retitle assets. If you own property in California, your attorney will normally prepare a deed that will be submitted for recording, and then it transfers that property into your trust. And then a power of attorney. Power of attorney allows for the financial management of your non-trust assets by another agent should you become incapacitated. So like your advanced healthcare directive, it's when you can no longer make the decisions for yourself. These are forms that you can use to nominate the people who will step into your shoes and take care of those things for you. And I know Catalina might add to power of attorney, but I think maybe once we
Yeah. Do you want to finish your presentation and then we'll hand it over to Catalina?
Yeah, definitely. And then last is nomination of guardian. And so that's found usually in your will. So whether it's just a standalone will or your pour over will, again, if you have minor children, you'll be able to nominate guardians in this document. So these are all, you know, very important documents that with a trust and a will, pour over will, complete in a comprehensive estate plan. So just so you know what these documents are. And then my last slide for my half of the presentation has to do with how do you go about looking for an estate planning attorney. Oh, and my left just off. And so, you know, something that we would like to recommend, I think both Catalina and I have seen examples of, you know, people making or people advertising services that are deemed more affordable because creating an estate plan can be, or it is an expense. However, we think that, you know, the peace of mind and relief that you find from creating this plan is worth it. But, you know, not to belabor the point that it can be expensive. And so just because someone is offering to do it for you for, you know, very cheap, you want to be careful with who's doing that. You want to make sure that you're working with actual attorneys. You want to make sure that these attorneys are barred and that they're not, you know, that they haven't been, that there isn't, you know, any accusations of misconduct. So something that we would recommend you to do is to look up that attorney. I have on here, if you just Google the California State Bar Attorney search, you can enter their name and you can always see, you can always confirm that, you know, yes, this is a licensed attorney in California. They're active and they don't have, you know, any issues around misconduct. So, you know, a lot of estate planning attorneys offer consultations. Some of them are free. So, you know, please, you know, you can interview these attorneys because they're going to be people who you're going to be working with, who are going to be doing this for you. So, you know,
Yeah.
it's it's um it's to your benefit,
Yeah.
to speak with them, get a sense of, can I communicate well with this person? Do they explain things well with me? Do they have
Yeah.
do they have an understanding of what I want?
Yeah. And
So
excellent
yeah.
advice, Daniela. Do your research, right? This is your money. This is your planning. So of course, with ARP, we always advocate, please, do your research. And of course, oh, actually, before we continue, I know that there were a lot of people joining late. I just want to introduce that we have two attorneys, specialists in trusts and wills and elder law, Catalina Reynoso and Daniel Hernandez, and I'm Patricia Perez. I'm an AARP volunteer and serve as AARP California's state president emeritus. And we're here giving you valuable information. Of course, if you have specific questions, please write them on the chat or in the comments if you're on Facebook. But please, this is your chance to ask questions. This is being recorded. So if you miss taking notes, later on, you'll be able to view this video. If you go to, and I'll give you more information, but if you go to arp.org/let's talk dinero, you'll be able to view this video later on. So sorry. So there's a lot of information that Daniela just shared. Now I want to turn it over to Catalina. Catalina, you want to share some insights, some details, complement
Sure.
what Daniela mentioned?
Yes, thank you, Daniela. I agree with Daniela on her last slide. We talked about doing your research. I just got a flyer in the mail for a complete estate plan for $500, and I will tell you when you start doing your research, you'll find out that $500 for a complete estate plan is crazy cheap. Unfortunately, estate plans can be expensive,
Yeah,
but when we researched this organization, they were not attorneys,
right.
and they do these presentations at Coco's and Sizzlers and la la la. And if it sounds too
Yeah,
good to be true, it probably is too good to be true.
yeah,
So
yeah,
I'm going to move into talking about conservatorships, and the segue flows naturally from Daniela's presentation because she touched on powers of attorney and advanced healthcare directives. And so, what happens when someone becomes incapacitated and they don't have a power of attorney or an advanced healthcare directive? In the scenario that I'm giving, I'm talking about an individual that was not born with a disability. I'm talking about an individual that had capacity to make their own decisions. And then, unfortunately, they never got these documents in place. And then maybe they get dementia or Alzheimer's or they have a stroke. And because of that new disability, they no longer understand what a power of attorney is, what an advanced healthcare directive is. And so it's too late for them to sign those documents. And now the only alternative is for their loved ones or a private professional to start a conservatorship. So a conservatorship is a court process for the rest of the life of the individual that is incapacitated. And what is the big difference here? With a power of attorney and advanced healthcare directive, the individual that's giving the power to an agent to make their decisions about their finances or about their healthcare, that individual is the one signing the document. So that's that first picture that I have, right? Maybe the individual did it before they became incapacitated. And so these documents are in place and we don't need a conservatorship because by the time that they become incapacitated, everything's already set up to have the people waiting in line to make decisions for that individual once they do start losing mental capacity to make their own decisions. When that doesn't exist, then you need a conservatorship. And the example would be you have a family member that now has advanced Alzheimer's where they can't make their own decisions, they can't go to the bank, they can't sign checks, they can't even make their health decisions. Now you need to start a conservatorship process. And the example I'd give is if my grandmother goes down that road, she doesn't have documents in place, I'd have to start a conservatorship process for me or another loved one to manage her assets and make her healthcare decisions. The big difference is how long it takes, how much it costs, and who is the person giving the power. So, with the power of attorney or the advanced healthcare directive, I told you the person who's now incapacitated signed that. So they gave the agent the power. With a conservatorship, that person can no longer give someone else the power because they don't know how to do that. They can't sign the power of attorney or advanced healthcare directive because they don't understand that. So the court is the one that's giving the loved one or the private professional that power. And because of that, if we really dig deep and look at, well, what is a conservatorship? I'm sure you've heard a lot about it in the news, and I'll get there. A conservatorship is taking someone's rights away because now we've deemed that it's dangerous for them to have those rights. But what rights are we talking about? The right to enter a contract, the right to manage their own finances, the right to make their own health decisions, the right to deny taking medications or refuse being in a skilled nursing facility. That's what a conservatorship is. And so because we are taking those rights away and giving them to someone else who we hope can be trusted to make positive decisions for this individual, it's not taken lightly by the court, right? The judge does not know you. The judge sees someone saying, "Hi, judge, I love my grandma. I want to take care of my grandma. Please give me the power to be their conservator." That judge doesn't know you. So there's going to be a screening process. Aside from the screening process, you have to come back to court every year to see how you spent that individual's money. And so it's because it is a lot more cumbersome, it's a lot more expensive as well. If we can go to the next slide, it's just a recap slide. So the next recap slide is, why would a conservatorship be necessary? You are already incapacitated and no one has authority to make your medical decisions or manage your finances or manage your care. So that's the little recap. It's get it done, because the person who might volunteer to be your conservator may not be the person that you would have chosen to manage your medical decisions or your finances. Why not get something in writing now? The nice thing about these documents is that you have a list of people, not just one person. You say, I trust my husband, but if my husband isn't available, has already passed on, or is incapacitated himself, then I trust my mom. If she's also gone, I trust my brother. And so you have a list of people that you trust, because like I said, perhaps the person who volunteers in the future might not be someone that you trust. And the nice thing about the documents that Daniela mentioned is that your advanced healthcare directive and your power of attorney can have different people listed. You might trust someone with financial decisions, but you don't trust that same person with your health decisions, or the other way around. And that's why we encourage people, get these documents done early. If you have a loved one who is, early onset Alzheimer's, it may not be too late, or dementia, it may not be too late. They may still be able to meet with an attorney, answer the questions that they need to answer to get these documents done. If you just got the diagnosis, this is the time to get in to meet with an attorney. Because if you wait longer, as we know, as the condition gets stronger and stronger, there's less capacity and there's less chances that this individual can sign those legal documents, and then a conservatorship would be necessary. So, one of the last pages that I have about a conservatorship here, um, changes to California law about conservatorship. So I have a picture of Britney Spears. This was a big word in the news for a long time, right? Britney Spears was conserved, and it seemed like it was so unfair. Why wasn't she allowed to marry? Why wasn't she allowed to make her own financial decisions? There was a reason that she was conserved, because conservatorships aren't just granted. We weren't part of that early process to see what the court pleadings were, what the doctor's determinations were. But because of all of the media attention to her case and other movies on Netflix about guardians or conservators coming in and just stealing from the elderly or stealing from the disabled, there was a lot of public backlash about conservatorships. And so that led to lawmakers saying, okay, let's take a look at this. What can we do to make sure that people are not inappropriately stripped of their rights and placed in a conservatorship? So now California courts are trying to avoid conservatorships for individuals who do not have severe mental capacity. What that means is that less restrictive alternatives must be attempted if feasible. What is at least a less restrictive alternative? A durable power of attorney, an advanced healthcare directive. And now there's something new, which we call a supported decision making agreement. A supported decision making agreement is not a power of attorney and it's not an advanced healthcare directive. Essentially, in that agreement, someone is just saying, I trust this person to help me, but they can only advise me. Ultimately, I need to be the person who makes the decisions about my health and my finances. But this individual can join me to my doctor's appointments, they can join me to my bank appointments, and they can help me understand what my options are, what the benefits and the risks are. So they're more involved in the decision making that I am doing instead of just, okay, this is my power of attorney agent and they're going to decide for me, or this is my advanced healthcare directive agent and they're going to decide for me. One note that I want to really drive home is that if you think there's a chance that this individual may not understand the power of attorney or advanced healthcare directive, you know them, right? They're in your family, you see them every day, you talk to them, and in your gut, you feel like, oh, I don't know, he or she might be a little bit too far gone to sign this. Don't do it. I've heard of people who print powers of attorney. They go to paralegals or they print it from online services and they have someone sign when really they know that that individual doesn't understand what they're signing, but they've heard how expensive a conservatorship is and how long it takes. That is fraud. And it's not just a civil issue, it's a criminal one. If you have someone sign a power of attorney or an advanced healthcare directive knowing that that individual doesn't understand what they're signing, you've now committed a crime that's punishable by time in prison and by civil penalty. So you'd have to pay fees. um, I say all of this because I really want to drive home that estate planning isn't just about preparing for death. Most people think, oh, yeah, I'm too young to have a will or a power of attorney, or I'm fine. Well, young people are on the road more, right? And a lot of accidents, unfortunately, happen on the road. Anything could happen. And so, why not be prepared? I tell my clients, I hope that when I give you this estate planning binder, you won't need it for several years. Like, I don't want to hear from your family 3 to 4 decades from now, right? And you never need these documents. But in the event that they're necessary, you have them. So you have that peace of mind. I tell my clients, I rather do an estate plan for you than help your family with a probate case or a conservatorship case. Because if I'm helping your family with a probate case or a conservatorship case, it means that you did not prepare. And now your family's picking up the pieces because you don't have the documents in place for them to help you. I could go on and on about conservatorships. The last thing I want to talk about before we move on to questions is that there are different types of conservatorships. The one that I described is where you have someone that doesn't have a disability, they're living their life, and then towards later in life, at whatever point, they become disabled. And so that's what we call a general conservatorship. There are also conservatorships for people who have developmental disabilities from birth or a young age, such as Down syndrome, cerebral palsy, autism. There's a ton of them. But for those individuals who lack capacity before they're 18 and are going to continue to lack capacity after they're 18, we do a different type of conservatorship called a limited conservatorship. And so there's three different types of conservatorships. I'm not going to get into all of them, but if you think that your relative might need a conservatorship, contact an attorney, because the biggest obstacles that I've seen with conservatorships are when people try to represent themselves. It can be done, but I think it just takes a lot longer because there's so many little things that need to be done that the court continues their case over again. So I see people coming in and then the judge says, Mr. Robles, I'm still missing this, or Mrs. Whoever, I'm still missing this. I'm going to push your case out a month. I'm going to push your case out 2 months. And so all of those delays add up. And in that whole time that conservatorship process is happening, there's no one making decisions for that individual.
Right.
And that's
Yeah.
why I think that there is a benefit, whether it's estate planning or a conservatorship, because the estate planning didn't get done on time. There is a benefit to working with an attorney.
All right. Thank you both so much for this information. I mentioned to everybody that this is being recorded. So if you miss anything, you want to review this, we'll be sharing the tape later on, the link later on for you to view. But I know now we're kind of tight on time and we have a lot of questions. So first question, is there a statute of limitations where Medi-Cal recovers?
I will say there is. I don't have it off the top of my head, but it starts running from when you get a letter confirming for Medi-Cal that you've already informed them that they've passed away. So if you're just trying to fly under the radar, someone passed away and you know that there is Medi-Cal recovery or there may be Medi-Cal recovery, if you haven't made the state of California aware, and it's the Department of Healthcare Services aware that that person's passed on, the statute of limitations is not ticking because you have to send them a death certificate and let them know that they've passed on, and you have to get a letter from them confirming that they know that that person has passed away. So if you don't have that, unfortunately, no, it can go on
Yeah.
forever because the clock isn't ticking.
Perfect. Thank you. Is Medi-Cal recovery only for payments to skilled nursing facilities or all care? For example, for cancer treatment?
Currently in California, it's for care in skilled nursing facilities. Yes, only.
Oh, okay, perfect.
Yeah.
That was quick.
But it could change, and that's what I
Yeah,
tell my clients. That was not the rule
yeah.
before. So the rule before was any care you received after you turned 55 was recoverable. It could be a doctor's appointment, a physical, it could be anything. From the time you turned 55 onwards, it was free game for California to recover. So there were tons of bills, and they were huge bills that changed, and now it's only care and skilled nursing facilities, but it could change. So why not get a trust to ensure that even if in the future it changes, you're covered?
All right. And speaking about being covered, if you put your assets in the trust, are they protected from creditors while you are alive?
Do you want to answer that, Daniela, or you want me to go ahead?
Sure. So, not necessarily.
Right.
They're not. When I brought that up, it was if you create a trust and you leave an inheritance for your children, and that remains in trust, that is protected from creditors, and like a potential divorce. But your own assets while you are alive, those assets in a trust are not protected from creditors. That's still accessible to creditors.
Catalina, anything else you want to add, or that's
No, we get a lot of calls about this, and it's just like Daniela said, if it's, we said you still own everything that's in your trust until you die. And
got it?
because you still own it, creditors can come after it. But
Yeah.
once you pass away, you can protect it for your children because you've already left
You
that
gave it to
protection
them.
in place.
Yeah, it's no longer yours,
Right,
but it's not a get out of jail free card while you're
right,
alive. All right.
exactly.
Okay.
It's not bankruptcy.
Exactly.
Yeah.
Yeah, exactly. Is the only asset, if the only asset you have is primary resident and the parties who inherit are in agreement, do you still need a trust? If all you have is your primary residence and everybody agrees who's going to inherit, do you still need a trust?
Yes, because when you pass away, that primary residence is going to have to go through probate. So even if everyone agrees, what do they agree to? It needs to be written down. So maybe you already have a will. If if you're fine with it going through probate, you can just use a will, but it's going to cost your beneficiaries of that will easily. Let's see, let me do the math quickly. Easily 5 times or more what your estate plan would cost.
Oh,
At
gosh.
least 5 times or more what your estate plan would cost. Um, I've seen, bills for probate attorneys in the 65,000 plus, because just like a realtor gets a commission, a probate attorney also gets a percentage of whatever they probate.
Of all the
So
assets, yeah.
a real property in California is worth a ton. It doesn't even matter how much equity you have in it. Let's say the example of you have a $700,000 home, but you owe half of it still. When you pass away, what the probate attorney is going to charge isn't based on how much equity you have, it's based on the $700,000. So your children might have to sell it or refinance it to get money to pay that probate attorney.
Oh, so plan ahead, people. And like you were talking about conservatorship, right? It's better to be prepared. And some of these documents are just great to have. The financial power of attorney, the advanced healthcare directive. I mean, all of these things are just good to have because you never ever know what's going to happen. All right. Can you borrow against the property or sell the property once it's in a trust?
Yes.
Go ahead, Daniela.
Yeah, like as we've mentioned, I mean, it's still, just think of it as everything is still the same. It's just a different name. So it's just going to be under the name of your trust as opposed to your individual name. But otherwise, everything else is the same.
Yeah. And you were talking about revocable, irrevocable. I guess we don't have a lot of time for talk about irrevocable. Well, once that's in that trust, then it's different, right? Then you have probably
Exactly.
trustees that manage that for you.
Correct.
All right. Let me see. We have another question. Do all siblings need to agree to sign, need to agree or sign to provide one sibling with a power of attorney for a parent? So do you need to get everybody to agree of who
No.
will be the
So
power of attorney?
I always tell parents the kids are not part of the planning process. I can't even schedule an appointment for a client if the client is the parent and the child is calling me to schedule the appointment. The ethics rules prohibit me from making that appointment. I need the parent to call me to make the appointment, and I need to meet with the parent alone. And it doesn't matter who agrees or disagrees with the parent's decision. The parent is my client, and so whoever they choose, that's who gets on the document.
Yeah. And Catalina, let's say if the parent is already not able to make that decision, then it kind of goes into conservatorship at that point.
I've seen it happen where someone who has diminished capacity signs a power of attorney for a child, and then all the other children are like, wait a minute, this person has not been involved in my
Oh,
dad's care or finances ever. And now they're the power of attorney. This doesn't seem like a decision that my father would have made if he had full capacity. So then the other children who are not the power of attorney start a conservatorship process to
and
try to get the
challenge.
order to appoint the judge to appoint them and say that that power of attorney is not valid. So
Yeah.
that's what we consider like conservatorship litigation if the parties don't agree who should be in charge. Yeah.
Yeah. And I think everyone knows of families falling apart because of these types of issues, right? Inheritance, wills, power of attorney. I mean, these decisions. I mean, it is sad, but that leaves it up to us to start making these arrangements, these plans, so our family is held together and intact instead of, the assets that we work so hard to earn, destroy our
Right.
family.
I
Um,
agree.
Before we wrap up, Daniela, any final comments, suggestions to people? We still have a few minutes. I just want to make sure you have time to give some recommendations, advice.
Thank you so much. I mean, I think a good takeaway too could be there are certain assets that you may have. So for example, life insurance or a retirement account, those usually are not placed in a trust or are retitled because those pass by beneficiary designation. So when this is like an action that you can take now, where if you created if you have a life insurance policy, you've named your beneficiaries, that's something that you can make sure to revisit to make sure that the people who you listed however many years ago when you first opened that policy are still the people that you want to receive it, the amounts and everything. So life insurance, retirement accounts, these are things that you have control over right now as well. So, going back and making sure that those either the people that you've named are the people that you want to receive, or maybe you didn't name anybody at the time, and so you want to make sure that you do name someone now. So just some, a piece of action that you can take today as well.
Perfect. Catalina, any advice, recommendations?
Yeah, I know that the cost is a big factor for people not to get this done. It's not cheap. I'm not going to sit here and say, call an estate planning attorney tomorrow and make an appointment if you know that that's a big hurdle. There are other services. The wait for those more affordable services is longer. But one place that I know, if you are a low income, you could contact an organization like the Disability Rights. I'm sorry, I'm blanking out right now. Give me a moment. Elder Law and Disability Rights in Orange County. That's what it's called. Elder Law and Disability Rights Center in Orange County. Let's say you need a conservatorship for a relative and you can't afford to pay for it. Either they can help you or they can refer you to someone in your county that can help you. I just don't want people to think I could never afford an attorney, so that's why I'm never going to get this done. Contact the state bar, like Daniela said. The state bar will have a list of pro bono or low bono. Most of those organizations, if they're nonprofits, for example, they do want proof of income because you have to be low income to get the free services. But if you have income, if you have assets to get this done, it should be a priority. We're getting towards the end of the year. Maybe it can be your resolution for next year. You know, um, get into an office and meet with someone that's going to tailor the estate plan to your needs, whether your family has someone that's disabled or someone that maybe is addicted to drugs, alcohol, and you want to protect their inheritance and make sure they don't use it for that. Whatever it is that you may need, even if you're already divorced or thinking about getting a divorce, there's so many different
Yeah,
things we could talk about. Don't
yeah,
trust one of these $500. Come to our
right.
presentation. I rather you go with a nonprofit or with an
Yeah,
attorney, but not go with the middle
yeah.
ground, which is tempting.
Thank you. Catalina and Daniela, if you don't mind, in the comments, put down your contact information so people have that for you.
Okay.
Thank you, ladies, for your incredible help. To all of you watching, you heard, right, of the various things to consider as part of your estate planning. Remember, consult a legal professional, anything regarding your own specific individual situation and future needs. We remember that also that ARP has retirement planning resources free as you're doing your research. Just go to aarp.org/retirement planning. Once again, go to aarp.org/retirement planning to get a lot of information. And for those of you who are caregivers, you can obtain a copy of AARP's Prepare to Care Guide by calling 877-333-5885. Once again, you can get AARP's Prepare to Care Guide if you're a caregiver by calling 877-333-5885, where you'll get tips, tools, and resources for family caregivers. And of course, once again, this is part of our Let's Talk Dinero series. Our next one will be Monday, December 18 at 4 p.m. Once again, Monday, December 18, 4 p.m. Join us for our next Let's Talk Dinero. You can view the video of this one and those that you've missed at aarp.org/Let's Talk Dinero. Thank you so much, Catalina, Daniela. Muchísimas gracias. Thank you both, right?
Thank you.
Thank you.
Catalina.
And
Thank you,
thank you
Daniela.
to
Thank you,
everybody
Patricia,
for
Adriana,
joining
everyone
us.
that helped.
See you next
Priscilla.
month. Hasta luego. Bye,
Bye.
everybody.